Jackie Dean.
Mr Chair, I want to go over one of the main provisions in this bill and return to clause 44A and just address some of the comments that a member across the House made. I do disagree with the member. I acknowledge his heartfelt intervention in this debate on behalf of his friend who clearly went through an incredibly distressing time which continued through the court process. So I do want to acknowledge that. But I do wish to take a different view of the impact of clause 44A. The member ascertained that the effect of clause 44A in the bill was an opportunity to delve deeper into a complainant's previous sexual history, and I will take a different view to that. Also, I will take a different view to the evidence that the member made that in clause, when he referred to clause 6C, around the interests of natural justice. It is not a judge's role to attack, I think the words were, a witness or a person in the stand. It's not the judge's role to do that. The judge, the member did say that, so I just wanted to mention that. So returning to the notice requirements for evidence of previous sexual history, what the bill does do is adds a requirement that the defence give notice before the start of a trial if they intend to use evidence about a victim's sexual history. Now, that is different with someone other than the defendant. So this was in fact a change which was recommended by the Law Commission and has been picked up in this bill. So the notice requirement will allow the admissibility of the evidence to be determined pre-trial. So it's not in any case an opportunity to delve deeper, but it is an opportunity for the admissibility of the evidence to be determined before the trial starts. At the moment, permission to introduce this evidence can actually be sought from the judge at any time during the trial. So it is my view, and it's the committee's view, who voted in favour of this part of the bill and this clause, is that clause 44A around notice of application to offer evidence or ask questions about sexual experience is an improvement on current practice. And with the member is saying across the House that isn't my argument, but it was certainly the argument that I heard, and it was at variance with the intent of the bill.
Dennis O'Rourke.
Chairman, I first of all want to